straight ahead on Law and Crime Daily.
We want to see black head coaches in the NFL and coaches of people of color and eventually gender.
Roger Goodell speaks out for the first time since the NFL is sued for discrimination. And 8 years after a deadly shooting, opening statements will soon be presented in the trial of an ex-police captain. Plus, Sarah Palin takes the stand as she sues the New York Times for defamation. The latest from the federal courtroom. But first, the death of Amir Locke. Hear from the 22-year-old's mother just 1 week after his death.
I sometimes have to put my hand across my chest to make sure my heart is still beating, because I've never felt such a hollow feeling.
Law and Crime Daily, covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer, along with Terry Austin. The mother of a man shot and killed by Minneapolis police as they served a no-knock warrant wants answers and justice. This, as newly released search warrants lay out why officers asked for a no-knock warrant. Law and Crime's Angela Levy is here with the story.
Brian, when Minneapolis police barged into that apartment back on February 2nd, they were actually looking for evidence related to a murder in which Locke's 17-year-old cousin, Mekhi Speed, was a suspect. Now, Speed is now charged with murdering a man in St. Paul. That man's name is Otis Elder. St. Paul, of course, is a sister city to Minneapolis. Now, body camera video showed that raid, and it showed the officers in the apartment and Locke sleeping on a couch with a gun he legally owned. Officers fired, killing Locke, who was holding that gun. Locke was sleeping in the apartment of his older cousin's girlfriend, not the apartment of Speed's mother. They were also searching that apartment as well. An application for the warrant says that officers wanted a no-knock warrant to, quote, prevent the loss, destruction, or removal of the objects of the search. It goes on to say that Speed and another suspect have a history of violent crimes. That is no consolation, though, to Amir Locke's mother, Karen Wells.
I want people to know that he was a bright light. He had a beautiful spirit. He was very respectful. We raised him on morals and values. He loved me. He loved his father. He loved all of his siblings. And anytime he came in contact with somebody and showed you his smile, they automatically gravitated towards him. I want them to ban the no-knock warrant across the United States. And I also want everybody that was involved in the execution of my son on 2/2/22, I want everybody brought to justice.
This was obviously very overbroad, even from the standpoint of issuing the warrants. They went into 4 different apartments. We've now learned from the affidavits that have been released. So, aside from executing the type of warrant that never should have been executed, it was overbroad, to begin with, based on our initial review.
Now, Karen Wells had a press conference in St. Paul, Minnesota with Breonna Taylor's mother, calling for a ban on no-knock warrants. Taylor, you'll recall, was killed in 2020 in Louisville, Kentucky, as police executed a no-knock warrant on her apartment. Mekhi Speed is currently charged with second-degree murder, and prosecutors will ask that he be tried as an adult. Meanwhile, the Minnesota Attorney General is investigating the shooting of Amir Locke. Brian?
Thanks, Angela. Joining us today is civil rights attorneys Sue Ann Robinson and Terry Austin. Sue Ann, all eyes seem to be on this no-knock warrant. What does it help tell us about Locke's death?
I think the warrant shows us that a no-knock warrant, is basically almost like a license to kill. And it's something that has to be very, very, if it's going to be used, it has to be done with precision. And what's shown on the document is there is a lack of precision. There is a lot of evidence in there discussing them surveilling the suspects and how they were following the suspects and following them to different areas. But there's no indication that they actually surveilled the suspects that they were looking for on the night they executed the warrant to make sure that they were in the place that they were executing a no-knock warrant. And that's why, there's an issue with it. I think the problem really is that we have to really look at these no-knock warrants as licenses to kill, because essentially that is exactly what could happen if you burst into a house in the middle of the night without announcing yourself, you could end up killing someone. And when a judge or when an investigator, a detective, a police officer is applying for something like that, it has to be done with higher scrutiny and higher precision. And it's just not there in this case.
Absolutely. Now, Terry, after hearing Locke's family speak, do you think there will be major changes in Minnesota to no-knock warrants?
Well, I sure hope so, Brian. The family was very impactful. They said the one thing they want is for the police officers involved, they want them fired and they want them prosecuted. And then as far as the no-knock warrants concerned, yes, Suann is right. There needs to be changes. We have to limit it to situations perhaps like when there are hostages, because otherwise we see these types of issues being raised, the fact that people are getting killed because they are shocked when someone barges in.
Especially in places where they have license to carry guns in their home. And Jeanette, Karen Wells mentioned one of the officers being brought to justice. What would she like to be done?
Well, she wants to see charges filed not only against that police officer who fired the fatal shot, but also, or the shots rather, but also the other police officers involved in this raid. She wants to see Keith Ellison's office bring those charges. You'll recall that Minnesota Attorney General Keith Ellison, of course, prosecuted Derek Chauvin. He filed charges against the other 3 officers in George Floyd's death, and he put out a statement last week saying Amir Locke's life mattered. I don't know if that foreshadows anything, but his office is looking into this.
Yeah, of course, we'll keep eyes on this case as it develops to see if there are any charges, whether it be a civil rights case charge at large or to those specific officers. Thank you, everyone. In federal court, a judge rules there is, quote, overwhelming evidence of guilt in Michael Avenatti's Nike case, meaning the disgraced lawyer will not receive a new trial. The ruling comes just 1 week after Avenatti's latest federal conviction for stealing some $300,000 from former client and adult film actress Stormy Daniels. Last summer, a U.S. district judge sentenced Avenatti to 2.5 years in prison for what he called an outrageous scheme to extort up to $25 million from Nike. On Monday of this week, Avenatti reported to federal authorities he is currently being held at the Metropolitan Detention Center in Los Angeles. Still ahead on Law and Crime Daily, jury selection winds down in the case of a former police officer on trial for murder. But first, one-time Alaska Governor Sarah Palin takes a stand in federal court. The latest developments in the New York Times defamation lawsuit next.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law and Crime Daily. Sarah Palin takes the stand in a defamation lawsuit against the New York Times. In her testimony, Palin referred to herself as David and the New York Times as Goliath, based on a 2017 story she says defamed her. Palin filed suit against the newspaper and a former editorial page editor for a story that linked a 2011 mass shooting in Arizona to her political activities. The former vice presidential nominee alleges the article said her political advertisement took aim at a victim of the shooting, an Arizona representative at the time. The Times says the article was corrected within a day. Palin testified this week, saying death threats to she and her family ramped up after the article. On cross-examination, she told jurors, quote, I can't specifically give you any name of someone who told me that they didn't want me to help them when asked about the effects of this article. The New York Times has not lost a defamation lawsuit in more than 50 years. Back to break down Palin's lawsuit is civil rights attorney Suann Robinson and Terry Austin. Terry, in a defamation case involving a public figure like Sarah Palin, she has to show actual malice by the New York Times. Do you see any here?
Actually, Brian, I do not see actual malice. It was defined in a Supreme Court case, and you probably remember this case, New York Times v. Sullivan. And where they defined it was they're saying it has to be reckless disregard, or the person who makes the statement has to know that it was false. And we don't have those facts here. Not only that, Brian, but there was a retraction and a correction immediately afterwards, within a day. So I don't think she's going to be able to prove that the New York Times acted with actual malice.
All right, so I'm reading Law and Crime's Adam Klasfeld's tweets. He's there in the court live tweeting. And Palin says this isn't about losing income, and she can't identify who shied away from her after its publication. So where are the damages?
I don't see the damages, and I think that's the problem. That's part of the problem with the case. I mean, aside from the fact that it's hard for her to demonstrate what was in the New York Times editor's mind, which is what would be required because she was a public figure, she would also have to demonstrate damages. She would have to say, hey, I had this contract with this media company, and after this was published, the contract disappeared, or I lost these speaking opportunities based on what was published, and those are my damages. I just don't see any damages here.
Yeah, maybe that 50-plus year winning streak by the New York Times may be extended unless we can see more from Sarah Palin in this case. But of course, we'll give you updates as the case continues. This week on Brian Ross Investigates, an epidemic sweeping the nation. Chief investigative reporter Brian Ross joins us now with a look ahead at this week's episode.
Thanks, Brian. This week on Brian Ross Investigates, an American scourge, not COVID-19, but the crisis with opiates that's claimed tens of thousands of lives. And no group in our country has been harder hit than Native Americans.
Most of us are living, at moderate to low income levels. We have lots of struggling families. And so we're susceptible to the folks getting caught up in the opiates. So it causes a lot of disruption to our families. They become dysfunctional, they become dependent. We have some challenges. Some will end up in other kinds of crime. And it's also spiritually for us and culturally, if I can say it that way, it's challenging for us because we consider ourselves strong people and we consider ourselves independent people. And then when you see some of your people start becoming dependent on opiates and other substance abuses, then it becomes very disruptive to the harmony of our community.
That's coming up this week on Brian Ross Investigates on the Law and Crime Trial Network.
You can catch Brian Ross Investigates Tuesdays and Thursdays at 5:30 p.m. Eastern Time here on Law and Crime Network. Coming up on Law and Crime Daily, NFL Commissioner Roger Goodell speaks out on diversity in the wake of a discrimination lawsuit against the league. Plus, opening statements will soon be presented in the case of Curtis Reeves. Still ahead, what's expected in the case that's taking years to go to trial. Welcome back. After taking a day off Wednesday, a full 12-person jury was selected on Thursday in a Florida courtroom for the trial of accused serial killer Robert Hayes. Hayes is accused of killing 3 women and dumping their bodies in the Daytona Beach area between November 2005 and February 2006. Authorities allege Laquita Gunther, Julie Green, and Iwana Payton were sex workers Hayes targeted. Hayes later moved to West Palm Beach, where he's accused in another woman's 2016 murder. It was after that alleged murder when authorities linked Hayes to the 3 shooting deaths in Daytona Beach. Jury selection consisted of attorneys asking potential jurors questions in groups, including asking if they could handle deciding this case as prosecutors are seeking the death penalty. Opening statements are expected to begin Friday. And jury selection stretched into a 4th day in Florida as a former police captain prepares to face trial 8 years after he allegedly shot and killed a man in a movie theater. Former officer Curtis Reeves is charged with second-degree murder in the shooting death of Chad Olson. Reeves and Olson were attending a showing of the movie Lone Survivor in 2014 when the two got into an argument over Olson texting during the previews. Reeves claims Olson was coming at him and said he feared for his life. He says he then shot Olson in self-defense. Back in 2017, Reeves argued his case in a stand your ground hearing, but a judge ruled against him. On Thursday, attorneys began with a pool of 52 potential jurors, working to whittle it down to a group of 10. Questioning focused on potential jurors' feeling on carrying weapons. While a traditional jury is made up of 12 people, Reeves' jury will be made up of 6 panelists and 4 alternates. 79-year-old Reeves faces a possible life sentence if convicted. Opening statements are expected to start on Friday. All right, so we've got co-host Terry Austin back with us to discuss the murder in the movie theater. Terry, what do you think the prosecution's strongest argument is in this case?
You know what, based on all the reports I've heard so far and what the attorneys have been saying during the voir dire, I think the prosecution has a very strong argument. Reeves is being charged with second-degree murder, which means that he had a depraved mind, that he had no regard for human life, and frankly, the fact that he shot someone to death because they threw popcorn at him and because they were using a cell phone, in my mind, means that he was disregarding life. And he was also charged with aggravated battery. And all you have to do in Florida there is to show that he was actually using a deadly weapon. And we know he was using a deadly weapon. So I think the prosecution has a very good case here, Brian.
I mean, I would imagine so, especially because Reeves lost his stand your ground hearing. Doesn't that mean he legally should have retreated before using deadly force against Olson?
Absolutely. That was a big loss for him. Under Florida law, you have the fact that you have self-defense, but if you see imminent threat of death or if you see imminent threat of danger to your body, then of course you can use self-defense, but you do have that duty to retreat unless there's the castle document, meaning that you are in your own home, or if you can show that you can stand your ground, you don't have that duty to retreat. But here he lost that argument. So I would say he would have to show he really was in imminent threat of death or bodily harm. And I think he should have retreated here, obviously.
Yeah, it's going to be interesting how that plays out with his status of being a former captain. Does it help or hurt him? You're going to have to tune into Law and Crime Network for gavel-to-gavel coverage to see how that plays out. When we come back, hear from NFL Commissioner Roger Goodell on allegations of racism and discrimination in the league, why he says the NFL fell short in promoting diversity among its employees. Welcome back to Law and Crime Daily. We're hearing from the NFL Commissioner Roger Goodell for the first time since the league was slammed with a diversity lawsuit. As co-host Terry Austin explains, that could mean major changes for the NFL policies.
Brian, in a press conference this week, Commissioner Roger Goodell said the league will soon reevaluate current practices, meaning there could be updates on even removal of the so-called Rooney Rule. This comes after former Miami Dolphins head coach Brian Flores filed a lawsuit against the NFL and multiple teams. Flores, who is Black, alleges he was only interviewed for a head coaching job with the New York Giants to fulfill the Rooney Rule, which requires minority candidates to be interviewed for head coaching positions. Court documents show text messages sent from Patriots head coach Bill Belichick to Flores congratulating him on the Giants' head coaching job before he was even interviewed. Belichick later apologized, saying he meant to text Brian Daboll, a white man who was ultimately offered the position. Last week, Commissioner Goodell released a memo saying the league's efforts to promote diversity when hiring head coaches have been unacceptable. On Wednesday, he doubled down on that, saying that racism and discrimination will not be tolerated and that changes need to be made.
It's really more important to talk about what Coach Flores was talking about and other coaches have talked about with respect to what really is happening in the hiring process. What's good, what's bad, what's not leading us to the results that we expect to have. We have spent an extraordinary amount of time with our committees, particularly our Diversity, Equity, and Inclusion Committee, but also with our membership in general, to sort of talk about the process. I think we made a tremendous amount, a lot of progress in a lot of areas, but not at the head coach. And that is something that is something we really have focused on to try to get the kind of results that we would expect. And we fell short of that by a long shot.
Commissioner Goodell said the league will hire outside experts in diversity, equity, and inclusion to review the league's practices. Brian?
Thanks, Terry. Sue-Ann, Flores' fight seems similar to what you do as a civil rights attorney. So how would you evaluate Flores' claim against the NFL?
I think, men lie, women lie, numbers don't. If over 55% of the NFL players are Black and less than 1% of the head coaches are Black, those are the numbers. With civil rights cases, a lot of times it's the plaintiff's burden to prove the discrimination. And I think in Brian Flores' case, he has a smoking gun in that, combined with the Rooney Rule, which requires a diverse applicant to be identified and interviewed, he has that text where the other candidate, the white candidate, is already being congratulated before he even has the opportunity to be interviewed. So that's something in a civil rights case you rarely get. It's a smoking gun into the mindset of the NFL. Like, hey, these guys are just trying to move around the rules to look like they're adhering to diversity, but in actuality, this is what's really happening. So Flores has a very strong case with that text message as a smoking gun, for sure.
All right, and I'm waiting to see Belichick deposed after that text message. That's going to be the exciting part. Terry, as the former chief diversity officer of a Fortune 500 company, what changes do you think the NFL should implement to make progress?
Listen, there's so much they could do, and Commissioner Goodell should not have waited until a class action has been filed. He needed to have implemented changes long ago. You could see that the Rooney Rule was not working, so you have to do more, and you have to make cultural changes. It starts at the top. Put your money where your mouth is. You have to interview candidates, look for them, get candidates who are qualified from diverse backgrounds. They're failing to do that right now. They're falling back on old habits and not really pushing forward. So much to do.
Yeah, we'll see how this lawsuit progresses. Thank you both. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.